Mr. B,
Hi.
people always think that our adult dependent relative cases can only be for their parents. But our recent appeal win says otherwise. It was a sister of the sponsor.
Yep.
Talk to us about that.
Okay, this was an adult dependent relative application we did back in 2023. It took a while for the Home Office to make a decision on that. They, of course, refused the application like they normally do for the adult dependent relative applications, and then we had to go into an appeal. The appeal bundle was prepared and submitted in November of 2024. So it took the Home Office, well, only about 10 months to look at it and decide that there was nothing for them to challenge anymore, and they accepted everything that we had submitted in the appeal bundle. So this is, in very short time, a second review that we have won with the Home Office before the appeal. And then they withdrew their decision, and she's now been granted status, which is indefinite leave to enter, because she fulfilled all the requirements of the rules. Now, what was difficult and different about this case? You're right, the vast majority of cases we do are to do with adult parents. I mean, parents are adults, but the elderly parents. Now, what happens in those cases? Those are the parents who are left by themselves, or one surviving parent is left by themselves and they can't look after themselves. And there are other people in the UK who are able to take care of them, and that's why we make applications for them. This was different because this was the sponsor's sister. So she was not an old lady, she was not an elderly lady, nothing like that. She was a young girl, but suffering from mental health issues. And that is the reason why we did the application. So when he first spoke to me, the sponsor, he was concerned because everywhere that he had spoken to people, they had always told him this cannot be done. He's a British national. He wanted to bring his sister, who's in her 20s, over to the UK. And he was being told that you can't do that because the immigration rules do not allow it. Now, when he spoke to me, I told him that we can still do the adult dependent relative application, because just looking at the rules, what do the rules say? Rules say by reason of age, illness, or disability, the person is unable to look after themselves and require long-term personal care. Now, if this is the law, you look at the law, and accordingly you can see that it is age related as well. So age doesn't only have to be old age, it could be earlier age as well. But this one was about the illness. So there was schizophrenia, there were issues about the mental state, and that is why it was being done. So I'm really, really happy that this was successful, because it was a very deserving case. So I'm grateful for the support of the family. They listened to me, they followed through with whatever I said. And the best part, like I always say, I am so proud of my team again for preparing a fantastic appeal bundle, fantastic witness statements, and the evidence that was in there to completely dispel all the objections raised by the Home Office. And that's why the appeal was not even, it didn't even go to court. It was allowed at the review stage, and she's already been granted status.
Mr. B, for argument's sake, let's say this wasn't his sister, but it was his auntie or cousin, but they had all the same mental health issues. Could we have still put in a case for that?
Yes, we could have, because it's about relatives. So you need to prove your relationship to the sponsor, and on that basis you can do the application. So yes, it can be done. And another thing to remember about this, even if you do not meet all the requirements of the rules, on the date of the appeal hearing, if you can win the case under the human rights, then you can still be allowed. And that is what happens in a lot of cases, where they can make an application, the Home Office does not accept some part of the rules, or the judge may not even accept some part of the rules, like for example, the adequacy requirement. It might be that they do not meet the financial requirements, but if they are able to show that there is a genuine need for somebody to be looked after, and there is a genuine dearth of carers in their home country, or any family members who can look after them, then yes, it can be successful.
So in those human right wins for the ADRs, they wouldn't get indefinite leave to enter, but they'll get leave to still enter.
In those cases, what happens is, if you win the case on the immigration rules, then you get indefinite leave to enter. If you do not fulfill all the requirements of the rules, but win it on the human rights grounds, then you are granted leave on a 10-year route, which means that you are first granted 2.5 years, and then you get your extensions every year, complete 10 years, and then you can apply for indefinite leave.
pretty clear. Thank you.
Thank you.